welcome everybody. This is the first Asper Center event of the year, and we've had a very exciting constitutional law time over the last couple of weeks. My name is Cheryl Milne. I'm the Executive Director of the David Asper Center for Constitutional Rights here, and I'm going to give a brief sort of overview or chronology of the events that have led up to today's panel and introduce our expert speakers to you. I'm going to start by saying that this is the events that have led up to today's panel. On July 20th, only weeks after taking office, Premier Ford announced plans to cut the number of city councillors in Toronto from 47 to 25 in the middle of the municipal election that had gotten underway in May. Of note was the fact that this issue was never raised in the provincial election campaign as a major initiative, except to say that this was consistent with their platform of efficient government. The bill also included the cancellation of elections for regional positions in Peel, York, Niagara, and Muskoka, with a return to an appointment process in those regions. The Better Local Government Act, also known as Bill 5, passed in August with no consultation or public input, and with the majority of the City of Toronto councillors and candidates opposed. Toronto municipal politicians filed an application in the City of Toronto to have the legislation declared unconstitutional. Legal arguments were heard on August 31st before Justice Belobaba of the Ontario Superior Court. On September 10th, at 8 a.m., he issued his ruling striking down the legislation as an infringement of the Charter 2B rights of freedom of expression of the candidates and voters of Toronto. A key aspect of the finding was the timing of the legislation in the middle of a municipal election. He also held that there was no Section 1 justification for the infringement, indeed no actual evidence respecting the objectives of the legislation, as noted in the infamous paragraph number 77, and I quote, "Crickets." Premier Ford expressed outrage about the decision, criticizing the power of appointed judges to overrule the legislative decisions of government, and vowing to use the Notwithstanding Clause of the Charter to reintroduce the legislation. He also stated his intention to use Section 33 in the future. Bill 31 was introduced on September 12th, now called the Efficient Local Government Act, including the use of the Notwithstanding Clause and a section exempting it from the operation of the Ontario Human Rights Code. It passed first reading along party lines despite stating it was to be a free vote. Perhaps it was. Attorney General Carolyn Mulroney stated in the legislature on September 12th, "We are using the Charter of Rights and Freedoms to uphold the Constitution." To say that there was turmoil in the legislature is an understatement. Protesters were arrested and kicked out. The government forced a weekend and late night sittings in order to get the bill to second and ultimately to third reading if necessary. On September 16th, 80 law professors, organized by Professor Brenda Kosman and Patrick Macklin here at U of T and Professor Martha Jackman at the University of Ottawa, signed a letter expressing serious concerns about the unprecedented invocation of the Notwithstanding Clause. The appeal was launched by the government in the Ontario Court of Appeal also on September the 12th, and a stay application was heard on September the 18th of this week, wherein the government sought a stay of the lower court ruling until the full appeal could be heard, effectively after the election. At this hearing, counsel for the government advised the court that if the stay were granted, the government did not then plan to go ahead with Bill 31 and would not be using the Notwithstanding Clause. On September 19th, yesterday, the Ontario Court of Appeal unanimously granted the stay, finding that there is a strong likelihood that the application judge erred in law and that the Attorney General's appeal to this court would succeed. We have today Professor Yasmin Dawood. She's the Canada Research Chair in Democracy, Constitutionalism, and Electoral Law, and an Associate Professor at the Faculty of Law. She is also cross-appointed in the Department of Political Science. Professor Dawood specializes in election law, comparative constitutional law, and democratic theory. Her scholarship, which is broadly concerned with electoral fairness and democratic governance, has addressed such topics as the right to vote, electoral reform, money in politics, redistricting, political dysfunction, partisanship, corruption, democratic decline, and the oversight of the democratic process by the courts. Professor Lorraine Weinrib, to her left, was appointed to the Faculty of Law in the Department of Political Science in 1988. Previously, she worked in the Crown Law Office Civil, Ministry of the Attorney General, Ontario, holding the position of Deputy Director of Constitutional Law and Policy at the time of her departure. Her work included legal advice and policy development on constitutional issues, as well as extensive litigation, frequently in the Supreme Court of Canada. As government counsel, she represented the province of Ontario in a case coincidentally called Ford in Quebec in 1988, where she successfully argued before the Supreme Court of Canada that the Notwithstanding Clause could not have retrospective effect. To her left is Stephen Barrett, a partner and litigation lawyer with the firm Goldblatt Partners in Toronto. He is part of the litigation team that challenged the legislation on behalf of city councillors and candidates. His charter expertise had been mainly in the area of 2D rights in respect of freedom of association, having appeared many times before the Supreme Court of Canada. He will be providing us with an overview of the litigation. I just want to make a shameless Asper Center plug here by noting that the litigation team from Goldblatt's included 2 relatively recent graduates of this law school and accomplished students in the Asper Center Clinic, Louis Century and Geetha Philippopoulos. For the students in the audience, yes, you can practice constitutional law. We don't have a government lawyer representative because of the controversial nature of this case. We, in fact, didn't believe that they would come on such short notice to comment on it, but we will try to present a balanced perspective on what their arguments were as well. And I'm going to turn it over first to Professor Dawood.
Thanks so much, Cheryl, for that very nice introduction and for organizing this great event. And also thank you to Tal Schreier for organizing it as well, and for everyone attending today. So as Cheryl mentioned, we don't have a government lawyer present, so I'm going to wear 2 hats. I'm going to be presenting both sides of the argument, and then I'll let my co-panelists engage in more of the editorializing in terms of their opinions on this case. Okay, so turning first to the legal framework. Section 92(8) of the Constitution Act 1867 gives jurisdiction to the provinces over municipal institutions in the province. So there are various provincial statutes which govern Toronto, including the City of Toronto Act, which delegates power to the city over various portfolios, the Municipal Elections Act, and there are all kinds of regulations as well. And then you also have, as part of this legal terrain, Section 3 of the Charter, which provides a right to vote in House and provincial elections. Section 3, as you now probably all know, is not subject to the Notwithstanding Clause, but the Supreme Court of Canada stated in a 2007 case that Section 3 only applies to House and provincial elections. And it specifically declined in that case to extend Section 3 to municipalities. So in light of this legal terrain, I think there are a lot of questions now about whether cities should have some independent standing in our constitutional order. So people have been floating the idea, for example, of having a constitutional amendment, a bilateral amendment, or even a full amendment that provides cities with some sort of constitutional status, but the way the legal terrain is now, they don't actually have any. Okay, now turning to the Ontario Superior Court judgment. So Justice Belobaba said right out the gate that Bill 5 does in fact fall squarely within the province's legislative competence, but he said that it nonetheless, he found that it breaches Section 2B of the Charter, and that infringement was unjustified under Section 1. So as a result of his decision, he said that the election on October 22nd will proceed under the 47-ward structure. And as well in that decision, he does reference other possible arguments. For example, arguments from Section 2D, Section 15, the unwritten principles of the Constitution, such as democracy and the rule of law, but he says he's not going to address those other arguments. Now, right after this decision came out, there's quite a lot of commentary about, oh, 2B doesn't apply to elections, and really it's only Section 3. But in fact, I think it's important to note that the Supreme Court's election law cases do in fact rely on Section 2B, right? There are cases that deal with freedom of expression, particularly with respect to campaign finance rules. So the question here is whether the use of 2B in this Superior Court judgment is consistent with the Supreme Court's election law cases where they've used 2B. So Justice Belobaba sets out two main arguments, and so I'm going to first talk about argument number one. And that first argument was about the timing of the law and its impact on candidates. And he said that because the bill was enacted in the middle of this ongoing election campaign, it breached the municipal candidates' freedom of expression. So the first question under freedom of 2B is whether the activity falls within the scope of 2B. That's the first thing you need to ask. The province on this point said that Bill 5 actually does not regulate activity that conveys or attempts to convey meaning, which is the standard that the Supreme Court has announced under 2B. The province said all this bill does is reduce the wards from 47 to 25. It doesn't actually regulate voting, campaigning, or political expression. And citizens and candidates do have the right to campaign and vote, and that is not being taken away. But in the Superior Court decision, Justice Belobaba said no, in fact, the activity does fall within the scope of 2B. And then he turns to the second question, which is whether there is an infringement. So under the standard, you have to show that the purpose or effect of the legislation is to interfere with that expression. Now, this turns out to be actually quite tricky. It's difficult, I think, to demonstrate infringement here. The court said that Bill 5 substantially interfered with the candidate's ability to effectively communicate his or her political message to the relevant voters, right? Because the 47 ward structure informed their decisions about where to run and what to say, how to raise money, how to publicize their views. They also had produced campaign material. And so the switch meant actually redoing all of that, right? Redoing their campaign and political message, getting additional financial support. And so all of that taken together, the justice said that this meant that their ability to convey their political message was severely frustrated and disrupted. And the court said that this amounted to a substantial interference with the candidate's ability to effectively communicate. And it's the fact that it all happened midstream that really is the source of the interference. Now, another part of the court's argument, and I should also at this point say that the decision is very brief. It's only about 20 pages. So there are parts of the decision that weren't actually fully fleshed out. So another part of the court's argument is that when the province has provided an electoral process, it cannot impose new rules that substantially interfere with the candidate's freedom of expression. So here, Justice Belobaba relies on an election law case, the Libman case, and uses that case to argue that where you've got a democratic platform that's provided, in this case, he argues the 47-ward election structure, an election has already begun, then any kind of expressive activity that's associated with that platform should be protected or is protected against legislative interference. Now, I don't want to get into the weeds too much. I know I've got a time constraint, so I'll resist the temptation to do that. But it would have been really helpful, I think, to have had more detail in the decision on this point and how exactly this connects to the Supreme Court standards when it comes to positive obligations in respect of Section 2B. So there are some cases where the court deals with this question as to, is there a positive obligation when it comes to Section 2B? And in the Hague case, which was another election law case, the court said that the state is not under a duty to extend a statutorily created platform to anyone, but it left open the possibility that 2B might in fact require positive governmental action. And then there was another case, the Bayer decision, where the court set out a test for positive rights claims under 2B. But again, we don't have a full analysis of this kind of positive rights argument in the decision. Anyway, going back to Libman, which was a case that involved referendum legislation, in that particular case, the actual legislation prohibited spending on political expression that was taking place outside of these national committees that had been established. So in that case, it was more clear to see that there was a ban on speech. And in fact, the court said there was an almost total ban on speech because unless you joined these national committees, you weren't able to take advantage of regulated expenses. I'm not going to get into all the details, but basically it prohibited an independent person from running a campaign during the referendum. So in the Libman case, it's a little more obvious that there is a negative infringement, and it's a little harder in Bill 5 to find that parallel, to find a clear prohibition of speech in the actual wording of the legislation. Instead, I think what we have is a diminishment in the effectiveness of speech that is already being engaged in, right? So it doesn't actually prohibit speech in the way that the legislation at issue in Libman did. Instead, because of the ward switch, it effectively diminishes the power of the speech that's already being engaged in, or the effectiveness of that speech. So one possible avenue that I'm actually interested in seeing how this might play out in theory anyway, is how would you be able to line up the decision, or how would you be able to line up this particular case more closely with Libman? So is there a way to think about the Bill 5 that actually aligns it a little more closely with Libman? And I think in the campaign finance aspects, maybe there is an argument that could be made. And I do know that the applicants, the claimants, did in fact make arguments on the campaign finance implications. So there was a regulation that came into effect on August 15th, which changed some of the campaign finance rules in the Municipal Elections Act. The province said in response to all this that these changes have in fact increased spending limits for the candidates because the wards are now bigger, and because these spending limits, the formulas are based on the number of electors in the ward, actually candidates now have increased spending limits. But it doesn't seem to me anyway that this response addresses the free expression rights of donors. So I'm very curious to hear what my co-panelists think about that, whether there is an argument that could be made for the donors' rights being interfered with or infringed quite seriously, because if they had donated money before to a candidate who now is no longer running, is it the case that that speech was infringed with, or is it the case that once you make a donation, you've actually engaged in the speech? There's no sense that it continues on until the election. Anyway, that's a question I had. So the second argument that Justice Belobaba, or the second sort of claim that he says that he makes, is about the content of Bill 5 and its impact on voters. And so the argument here is that Bill 5 almost doubled the population size of the city wards from an average of 61,000 to over 100,000 people. And by doing so, it breached the municipal voters' right to cast a vote that can result in effective representation. So this concept of effective representation was announced by the Supreme Court in the Saskatchewan reference many years ago. And there the court said that the purpose of Section 3 of the Charter is effective representation. So right away, what was interesting about this way of putting together Section 3 and Section 2b is that this has not been done before, at least by the Supreme Court, right? To say that concepts from Section 3, like effective representation, can be brought to bear on Section 2b, freedom of expression. Justice Belobaba is aware of this. He says that, he raises the question, is it possible to do this? Is it possible to import basically these values or these arguments from Section 3, the right to vote, into Section 2b? And he concludes that yes, the Supreme Court's take on effective representation under Section 3 can be applied to municipal voters' rights under Section 2b, because obviously they don't have the right under Section 3, I guess would be the idea. So to sort of build up a right under Section 2b. This is a novel argument under the Supreme Court's precedents. It might get accepted by a Supreme Court sometime in the future if there's, but we can't say that that's necessarily going to happen or even likely to happen. And as you know from as I'll talk about in a minute, the Court of Appeal was actually quite skeptical that that would be a winning argument. So then with Section 1, Justice Belobaba said it's not saved under Section 1. It fails at the first step, pressing and substantial objective, which, as you know, is kind of an unusual place for a case to fall. The court said there was no evidence that the two objectives, which were at that time efficiency and cost savings, were so pressing and substantial that Bill 5 had to take effect in the middle of the city's election. And he also said that it could not satisfy proportionality, especially minimal impairment. So then, as Cheryl mentioned, the Court of Appeal came down with its decision on the stay yesterday. And I won't talk about the arguments around the stay itself. There are a whole bunch of legal requirements around that. I just want to focus on going back to the election law questions. And there the court said that there was a strong likelihood that the application judge erred in law. And the basic reason was that, according to the Court of Appeal, was that the interpretation in that decision, in that lower court decision, appears to stretch both the wording and the purpose of 2B beyond the limits of that provision. So the Court of Appeal was of the view that Bill 5 does not limit or restrict any messages, I'm quoting here from the decision, does not limit or restrict any messages the candidates wish to convey to voters for the remainder of the campaign, nor does it erase messages conveyed earlier, or although it may reduce their effectiveness. Another thing the court said is that there's still enough time until voting day to adjust the political messages. So the candidates still have, I guess, about, little less than, or I guess about a month left to adjust their political messages. Of course, this immediately raises the question of what if the law had been passed a week before the election, right? Is that sufficient time to, put forward your message? It's not really obvious. It's not clear to me that that has been addressed at all by this decision. And it seems to me that couldn't be right, that you could change it 1 week before and still say that there's been no infringement. The Court of Appeal also said there's no constitutionally guaranteed right to the 47-ward platform, but in fact, Justice Belobaba never claimed that there was a constitutionally guaranteed right to that. With respect to the Section 2B rights of voters, here the Court of Appeal took exception to that blurring, which I had mentioned earlier about importing ideas and standards from Section 3 into Section 2B, and basically said that doubling the ward size did not interfere with voters' 2B rights. Okay, so that's basically an overview of the decision from sort of an election law perspective. And what I want to say now actually is something a little bit different, which is the following. Democratic stability and functioning depends on the interaction of all these rules and constitutional provisions and cases with norms that ought to guide political actors. And I think this case really demonstrates the importance of norms for democratic functioning. In my view, and here I'm taking off my balance hat, I'm just speaking as myself, in my view, interrupting an election midstream is inappropriate and completely inconsistent with notions of democratic and electoral fairness, even if it's the case that the provincial government has the power to do so. This norm of forbearance, in other words, for governments not to use their powers to the full extent possible, is crucially important in a democracy. It's also implicated, I believe, in Premier Ford's invocation of the Notwithstanding Clause, and I'm sure Professor Lorraine at Weinrib will have something to say about that. The norm of consultation is also here, at issue here. I think that even if consultation is not legally required by the province, there absolutely should be a process that involves all the relevant stakeholders. That's essential for democratic legitimacy. That's essential for procedural fairness. That's essential for electoral fairness. So all this to say that, in my view, the province's actions, even if they were found by the court not to violate the law, are still deeply problematic with respect to these important norms of procedural fairness and forbearance that ought to govern political action. Thank you.
I'd also like to thank Cheryl Milne for organizing this and making it possible for all of you to share with some of us who think about these things very deeply, and even when they're not part of the crisis atmosphere of Ontario politics, and to work through some of the big issues and some of the more mundane issues that have developed. I'm going to speak about the override, and it's, I think, very unfortunate that we're talking about the override in this context, because in a way, this constitutional crisis, and I use that word with care, is really a constitutional tempest in a teapot. The Premier could have acquired an electoral mandate on this. He could have alerted the city that this was going to happen. He could have easily done this for the next election. There's no evidence of urgency. And there, unfortunately, from the Premier's comments, are a lot of indications that his motivations are not of the most, they're not the most conducive to the position that he occupies or the role that the Attorney General should be providing and giving him advice. So this really didn't have to happen. And we have enough constitutional challenges that we can't avoid, that it's very unfortunate that a new Premier coming into office decided that this was something that was important enough to do, because it has been destructive, it's thrown everyone into confusion, it has jeopardized the stability of municipal government in one of the most complex governments in the country. And so it's unfortunate that we're in this situation. Since the override has come to the fore after lying dormant in the background for quite a long time, it's important to always go back to the basic primer on how the override got into the Charter. It's quite a distinctive type of provision to have in a Charter. So let me take you back to 1981, when there was an impasse between Prime Minister Pierre Trudeau, whose life project became giving Canada a Charter of Rights and Freedoms. And that project was strongly resisted by a number of premiers, 8, so not an insignificant number, with only Ontario and New Brunswick supporting the project. The 8 premiers were very effective for a long period of time when negotiations were going on and drafts of the Charter were being produced in convincing Trudeau that if he made concessions on the number of rights and the strength of the rights, that he would eventually get a weakened Charter, but he would get his Charter. And Trudeau played that game for a while until he realized that this was a game, and that it was a stalling game. And he expressed his end of this type of negotiation by saying, "I will no longer trade rights for fish." Now, that might be a little bit opaque. But what he meant was that he was, at that moment, in a fierce battle over particular rights that he wanted to have in the Charter, and the Premier of Newfoundland was insisting on getting more jurisdiction over fishery. And Trudeau said, this doesn't make sense. I don't have to negotiate people's rights. Now, Trudeau prevailed, partly because of his political acumen, as I'll point out in a moment, but he could not have done it if it weren't the case that the Charter was enormously popular across the country, including all the provinces of which the premiers stood fast against the Charter, and also in Quebec, which of course ultimately repudiated the Charter and is on record for using the override more than any other province. The 8 premiers were bound in a pledge of solidarity that none of them would bend or concede anything to Trudeau without meeting with the group and letting the group make a formal decision together. There was strength in numbers. At the last meeting where the compromise, the insert of the charter into the package occurred, there was a very dramatic moment in a publicly televised opening session of the First Minister's Conference when Trudeau set out the position in great detail and the impasse, and then turned to Premier Lévesque, the separatist premier who was representing his province, and offered a referendum on the charter. Quebec, in the separatist position, was going to reach its independence through a referendum, and Lévesque, on the spot, on national television, had to say yes, and that broke the solidarity of the Gang of Eight, and there was a huge scramble, and everyone stayed up all night. It was very exciting, and in the morning there was a compromise, including the override, which was brought together in a hotel kitchen. Okay, so the override came in as a compromise in which the premiers had a very weak bargaining position because they did not have electoral support in their provinces for their opposition to the charter. They took what they could get. It wasn't the strength of their position that produced the compromise. Trudeau had a number of plans, and he was confident that he would get the amendments from the UK, and he had said that if he didn't get the amendments from the UK because the UK thought there weren't enough provinces on board, that he would declare a unilateral declaration of independence from the UK, and that would probably have been just as interesting as having the override on the front pages of the last few days. And then he would create arrangements for a referendum on an amending formula, and then he would adopt the charter. So he had a scenario, and I actually do believe that he would have carried that out. But the pivotal break was that Ontario stepped up, and the Premier and the Attorney General of Ontario said to Trudeau, "You must compromise because you will lose Ontario's support." And Trudeau knew he couldn't go to the UK without any provinces and support. And so the override was cooked up, and I'm sure, as you all know now, if you didn't know 2 weeks ago, the override empowers a province or the federal government to suspend for a limited period of time, a maximum of 5 years, the fundamental freedoms, the legal rights, and Section 15. At the end of the 5 years, the override lapses, and the rights revive unless the override is renewed. And the 5-year period was chosen because it coincides with the period of elections. And I've written on the political history of the override, if any of you are interested in the uses and, more importantly, the non-uses of the override. And the burden of having to renew the override has become, in a sense, a larger burden than actually invoking it the first time because it becomes an election issue. Okay, so how does this compromise actually work out? Well, if you've been reading the paper closely, you'll see what turns up constantly like a religious ritual whenever the override comes into play, that everybody knows what was intended. Okay, so I read these descriptions, and since I was a government lawyer at the time, and so I know the public information, and I know the private information as well. Most of what is said about the intention is absolutely wrong, but I have, straight from the horse's mouth, so to speak, a statement from a friend of mine who was in the negotiating position at the time that the override was being negotiated with the federal government on behalf of the provinces. And he's written the definitive book on this, and it's all footnoted completely, but he wrote to me just the last few days, the opposing premiers believed that a safety valve was needed to allow legislatures to remove charter-based rights or overturn charter decisions whenever legislatures feared that granting the right would threaten political stability or interrupt important public regulation, that it would be rarely exercised, and only when the exercise of a charter right would fundamentally damage society's stability and well-being, and it would be necessary before invoking the charter to publicly calibrate the harms that recognizing the right would cause, and to establish publicly the reasons for using the Notwithstanding Clause. All right, so I think that it's very important to look at the actual history and not the political hopes of people who were against the charter as to what the actual meaning of the compromise was, always keeping in consideration the fact that the premier's position was actually very weak because of the strong public support of the charter, and the fact that Ontario had to intervene to actually prompt the compromise. Okay, so all of this is to say that we have to understand that the charter guarantees are the norms and the with constitutional status, and the override is a political exception to these judicially protected norms. So what follows from that? Well, one of the things that follows is that the override is understood to be prospective only. Now, I'm not arguing for this position. I'm not speculating. The Supreme Court of Canada decided in a case coincidentally called Ford v. Quebec that the override can't be used retroactively. And what that means, and this is contrary to what you've seen in the press, if you've been reading widely, the override doesn't affect the judgment of Justice Belobaba, because he is determining the question of whether there were rights and whether they were breached and whether the breach was justified in the period before the override came into effect. Of course, it didn't come into effect at all, but so in this period, the rights were not suspended. And this is very, very important, because if the override could be used retroactively, all that legislatures would have to do is threaten to override. If, let's say, in a hypothetical situation, there was something really important at stake here that had to be done urgently, and a government threatened to use the override to say, people can't discuss whether it's proper to use the override or not. We're suppressing freedom of expression about whether the override is a good thing to do or a bad thing to do now. That's one thing if they do it prospectively. But if they threaten to, if they have the power to do it retroactively and they threaten to do it retroactively, then they've taken away your right in the moment where the law and the Constitution says you have the right. And you can't have confusion, you can't have confusion as to what the rules of the election are in the middle of the election, but you also can't have rules at any moment as to whether your constitutional rights are in force. So it's completely contrary to the rule of law, and the Supreme Court of Canada said to the text of the Charter and our legal system's aversion to retroactive law that the override would operate retrospectively. Okay, now, the override instrument that the government created actually has some literally written in retroactive provisions, but also I would argue, after Professor Dawood's description, that freedom of expression during an election is very encompasses the core political speech, which is the speech that individual candidates express in so many ways to the constituents who are able to vote for them. If there is any uncertainty when the candidates are speaking as to what the riding boundaries are and who the electorate is within that boundary, then there is, I think, a very serious encroachment on political speech in an election period where we are voting for people, after we do all sorts of different kinds of scrutiny, who are going to represent us in our constitutional democracy. So I think there is actually a serious breach here. But the point I want to make in terms of the override that's significant, I think it's a breach in the circumstances in which it would have been invoked that would have been retroactive. So we would have had the situation of whether the use of the override clause had been invalid. So why a government would want to put us in this situation, I absolutely don't know. I can't imagine that the lawyers who are in the Ministry of the Attorney General Constitutional Law Branch did not tell the government that there is a retrospectivity problem here, because you start an election, everything builds. You have the money, you have the volunteers, you have all that. You expend all that energy and personal resources and social capital, and you interact with your constituents, and then suddenly they're not your constituents anymore. This seems to me to be retroactive. So in terms of the breach, I think there is a breach, and I think that the overriding of the breach would have been retroactive if the government was able to put it into effect, and then there would have been a constitutional challenge of that, and to what end in these circumstances. Okay, so I want to just briefly say that there are two other ways that the override would have been used in these circumstances. I'm not sort of making up sort of false problems. And these were actually also characteristics of the override that was examined in the 1988 case. And in that case, on behalf of Ontario, I was successful to argue that there was an invalidity of the use of the override because of the retroactivity. So I was successful in that. The court frowned on the other arguments, but I don't think it actually dismissed them. And I think the court's extensive jurisprudence on constitutional principles since 1988 would be exactly what was necessary to support the arguments that I made that they basically didn't want to contemplate at the time in 1988, because basically in the back and forth of questioning during the Supreme Court of Canada oral argument, they were basically saying to me, look, we've got a lot on our table. We don't know what the rights are. We have to delineate the scope of the rights. We have to figure out if they're breached. We have to figure out if there's justifiable limitation. We have to develop tests for justifiable limitation. Give us a break. Do we have to really judicially review the exercise of the override? And I sweetly smiled and said, yes, you do, my lords. Okay, so what are the two other ways of using the override that I think are illegitimate? The first is not to specify which rights you are overriding, especially if you've already had a judgment that, whose effect you want to override prospectively. Okay, so there's all these sections that you can use when you there are all these sections that are subject to the override, but the Quebec Court of Appeal decided in this Ford case, before it got to the Supreme Court of Canada, that to put all the sections, a kind of boilerplate formulation, in the statute means that the general public, the voters, the people whose rights are being suppressed, just have something incoherent before them. They can't really judge it. So when you look at the boilerplate here, you've got a freedom of expression argument that's been developed successfully, and then you have the court overriding all the legal rights, all the other fundamental freedoms, and equality. So what's going on? So I think this boilerplate use doesn't make sense, and what the Quebec Court of Appeal said is that people have to know what their rights are and what the government wants to do with the rights, and they're entitled to know how this statute might operate in terms of those rights, so that this indiscriminate use of the override as extensively as possible in terms of the rights that can be overridden, according to the line of thinking which the Court of Appeal in Quebec accepted, that's unacceptable. Okay, so that's number two, retroactivity being one. Non-specificity of the actual right that you think is you need to suspend in order to actually have your preferred policy prevail. The third use is routine use. Now, what Quebec had done to voice its strong objection to the adoption of the charter without its consent is it had put an override in every single statute, every old statute, every new statute, every amended statute, this is turning the exception into the rule. It's turning the whole charter upside down. It is, and this is exactly what the Premier said he wanted to do. You know, who are these judges? They're appointed by my political enemies. I mean, he shouldn't say these things, even if he believes them, because they invite the kind of criticism that I'm making, that this is an assault on the charter itself, and there's no way that this historical compromise should be turned into exactly what it wasn't. It was a narrow exception. It was necessary to provide the charter. I actually am in favor of the override being there, but that's a whole other story. But I think that the idea of suppressing the override retroactively and to the extent possible by naming all the rights, and then to announce, in a sense, a policy for the future of using the override whenever these elected, appointed judges strike down statutes, that this turns the exception into the rule, and we need, I think, a court ruling to examine this, not in the boiling pot of a constitutional crisis, but the fact that Quebec did this, and then the fact that Premier Ford seems to have this in mind, and he has very, very good legal advice. He knows, you know, he knows what he's doing. I think that this is something that should be referred to the Supreme Court of Canada, so it gets straightened out just in a very cool period where there's no specific politician whose political agenda is on the line, and that the full application of the constitutional principles to the interpretation of the extent of the power of the override be authoritatively determined, as many reference cases have done in the past, so that we can go forward and we know what the rules are, and particularly we know when we have our rights in real time, and the power of a provincial or federal government can't reach back in time and take away rights that we actually exercised in the moment, in real time, that we know that the override is used as narrowly as possible to serve the government's purposes, because the governments have these powers, but with deliberation and hopefully with strong court determination of the sort of the fact that there's a breach, and the third, an announced policy of a government to use the override regularly should be considered inappropriate to such an exceptional use of public power.
So I wasn't really going to talk about the override, but maybe I will talk about it a little bit. Certainly, one virtue of the Court of Appeals stay decision is that all of these issues probably won't have to be dealt with, at least around Bill 5. But I guess the difficulty I have with some of Lorraine's comments is that although I would prefer to think of the override as a narrow exception, it's the language in Section 33 is incredibly broad. Like, sure, there's a constraint on using the override retrospectively, but you know what Premier Ford said is, I'm using the override because I'm elected and judges are appointed. Now, if that rationale for using the override is acceptable, then one could justify using the override all the time. And I think one of the concerns that as lawyers and as law students we might have is that actually, will the Supreme Court of Canada or courts actually engage in substantive review of governments resorting to the override? And it's not at all clear to me. There was actually an excellent symposium at the University of Ottawa Law School yesterday, focused specifically on the override. It's not at all clear that the courts are going to impose substantive limits on the override. So although the intention may have been narrow, if one can resort to the intention of those who drafted the charter, and I suspect many of the 80 law professors who signed that manifesto about not resorting to the override generally aren't big fans of looking at the intent of the framers of the charter when it comes to giving a broader view to charter rights. So there's a bit of a tension there as well. In any event, suffice it to say, just on this retrospectivity argument, which we gave a lot of thought to, thinking that we might be successful on the stay and therefore face the override, I think what the government would say, and it sort of is part of what the Court of Appeal has said, and I'll come back to this, and I think it's somewhat disingenuous, is that, well, look at it this way. We canceled the election that started May 1st, and we're just starting a new election from, it would have been, I guess, August 15th, save for Justice Belobaba's decision, with a truncated election campaign period. But there's nothing retrospective about that, and we're entitled to change the election rules in terms of having a new election. As I say, I think that's somewhat disingenuous, but I'm not sure that that isn't an answer to the retrospectivity point. So we're not going to have to deal with that. What I want to deal with is actually just to talk about how we viewed the case after we were retained by candidates and electors to challenge the legislation. And let me ask you this. How many, I know there's people online too, but how many in this room thought what the Ford government did was unfair, the change they made? And that's a pretty overwhelming hand raising. How many of you thought it was unconstitutional? Now that you know what the Court of Appeals said, you have a little bit of a guidance, but before the Court of Appeals decision, how many thought it was unconstitutional? Much fewer. And so so the challenge we had was that everyone seemingly agreed that changing the rules mid-election was terribly unfair, but we had to persuade a court that it was also unconstitutional. I just want to focus on the argument that we've been talking about, which is the freedom of expression argument and the notion that changing the rules and boundaries of an election in the middle of a campaign implicates and infringes freedom of expression. There were a number of other arguments made, including very interesting arguments around the unwritten principles of democracy and the rule of law. But the main focus, at least of our argument, was that legislatively intervening to change electoral boundaries in the middle of a campaign engaged expressive activity, Section 2B activity, and interfered with that activity. And there are really three prongs to the way we conceived of the argument. And because the decisions, both the Court of Appeals decision and Justice Belobaba's decision, were produced extremely quickly, when you end up practicing, you'll never have a constitutional case that gets decided on the merits 2 weeks after it's initiated. It just doesn't happen. It usually takes years and years. But the three prongs were, first, you have to view an election as taking place over a space and time, I'm not a physics professor, but over a space and time continuum. That's what elections are about, a campaign taking place over time and within geographic boundaries, within fixed spatial boundaries. And potential candidates decide whether to run for office, how to strategize, how to hone their message, very much in relation, particularly municipal campaigns, but equally true in federal and provincial campaigns, around the electoral district or boundary in which they're going to be running. And in fact, we led evidence from candidates and organizations who were active in this election, including one of our clients trying to get more women elected to city council, talking about the strategic choices they made about whether to run, who should run, how to run, what type of message, based specifically on the 47 ward boundaries that we all knew were going to be in place no later than January 1, 2018. And their messaging and their expenditures that they were free to engage in from May 1, because that's when the campaign started, were very much structured by those boundaries. Now, so that was the first point, that that's what an election is. So secondly, that all of this activity running for office, all the messaging it entails, all the communication and advocacy aimed at voters. And the act of voting itself involves core political, electoral, Section 2B protected expressive activity. You know, the Irwin-Toy test, which is, are you intending to convey meaning, has been interpreted very broadly, particularly in the political context. So the second prong of what we said is this is all about expression. This is core political expression. And third, and this follows from the view of elections as involving this continuum and involving very much at its core the exercise of expressive activity, changing the boundaries and rules, because there were associated rule changes, midstream in the middle of an election can't help but interfere in a non-trivial way with all of that expressive activity. Put another way, at the core of our case, which in essence I think was accepted by Justice Belobaba, was the proposition that the unfairness that all of you sensed about mid-election boundary and rules changes is at one and the same time interference with expressive activity. The unfairness is the breach because it's unfairness in relation to core political expressive activity. And in order to have that sort of appropriate continuum of space and time in an election campaign, the boundaries and the rules have to be established and known at the outset of the campaign so that candidates and voters alike can know those rules and engage in all of the expressive activities that is the stuff of running for office and of voting. So that was our simple argument, and you know, precisely by undermining the fairness of the process, mid-election changes constitute the breach. We led, and it isn't just a matter of principle, we led evidence from candidates and organizations supporting them about the impact that the boundary changes, the reduction from 47 to 25 wards, mid-election, had on all of that electoral expressive activity, both looking back and looking forward. For example, when it comes to money, just picking up on your suggestion, money, and really from the candidate's perspective, I'm thinking, but this would also be true of the donors, I think. Money had been raised, expenditures had been made within limits, messaging and literature developed, printed, distributed in many cases, on the basis that you were appealing to a particular group of people living in Ward 14 or whatever. And that, all of that expenditure, resources, communication has been rendered, if not useless, certainly much less useful by the changes to the boundaries. And the financing rules that are contained in Bill 5, that money is gone, and that money spent still counts towards the limits. So even on that narrow ground, there seems to be a problem just using traditional election 2B law. And the other thing, I don't want to lose this point, it left some candidates who had engaged in that fundraising and those expenditures at a disadvantage relative to others. And that was part of what formed the basis for our Section 15 equality claim. Because in this election, there was coordinated activity by groups that traditionally have been not elected to council, that are protected by Section 15, whether women or racialized candidates and other groups. And the change in the rules actually had a disproportionately harmful impact on them as opposed to candidates who had easier access to resources, for example. So that was the argument, and I think that's the argument that Justice Belobaba accepted more or less. Now, in the Court of Appeal, that argument didn't go so well. And it's actually unusual on a stay for a court to wade into the merits of the underlying legal issues. Usually on a stay, if you're the applicant seeking a stay, All you have to show is that you've raised an arguable case on appeal. Now, we argued, and perhaps we were hoist on our own petard here, we argued, I think correctly, that when a stay is effectively determining the outcome of the litigation, which I think we all have to accept that decision yesterday did, that we're going to have a 25-ward election in Ontario. Then there's a higher burden on the applicant to show a likelihood of success on appeal. And so we argued that, thinking that the government couldn't meet that burden, or we wouldn't have argued that, I assure you. We were wrong, as it turned out, and much of the focus, interestingly, of oral argument was the judges on the Court of Appeal directing counsel, instead of directing them to the usual stay factors, irreparable harm, balance of convenience, members of the panel kept on saying, but can I hear from you on Section 2? And I think that we probably thought that, well, they wanted to hear the government because the government couldn't possibly meet the burden we said they had. In fact, as it turned out, they were going to find that there wasn't a very strong case on Section 2 that we had brought. In fact, the government had a strong case that there was no breach of Section 2. So I want to just talk about what the court said about why that was the case in the rest of my remarks. So the first thing the Court of Appeals said is that the approach that Justice Belobaba had taken, the approach that I've articulated here a few minutes ago, stretched the wording and purpose of Section 2B beyond its limits. Now, this will be argued on appeal, assuming an appeal goes forward, and certainly what we'll argue is that given Irwin Toy and the broad conception of freedom of expression, it's not at all clear, respectfully, how that is the case, particularly since this case actually involves what the Supreme Court of Canada has consistently said is the most important component of freedom of expression, namely political speech, speech around democratic institutions of government. The court does say at one point there's no right to a 47-ward election. Of course there isn't a right to some constitutional right to 47 or 25 or 63 or 12. What we argued was that the effect of changing from 47 to 25 in the middle of a campaign had an impact on these expressive activities. There's no freestanding right, but there's legislation that affected expressive activities. And the second thing you're supposed to ask in the traditional Section 2B analysis is the purpose or effect of that legislation to interfere with expressive activity. Now, purpose usually means you're limiting the expression because of the content of what someone's saying. And we didn't argue that here, although as I suggested before Justice Belobaba, perhaps we could have, particularly given the Premier's repeated talk about left-wing councillors and how this is just about left-wing councillors being unhappy with the changes, and certainly the impact of the changes was in many of the wards that did not have an incumbent when it was 47 wards, there were strong campaigns being made by progressive candidates. Those wards have disappeared. We now have, I think, of the 25 wards, I think 23 have incumbents. So one might have made that argument. We didn't. But we said the effect was, Irwin Toy says, well, when you look at the effect, you ask, among other things, does the impact on speech undermine sort of core purposes of freedom of association? And one of them is participation in political decision-making, which we, I think, say quite properly includes campaigning, running for office, the electoral, everything that's involved in elections. So the Court of Appeal was particularly focused on the fact that candidates could still run for office in the truncated period under the boundaries that were changed mid-election and express themselves. And for us, what we argued was that that's absolutely correct, and what we'll argue on appeal, that's absolutely correct, but the legislation has really limited the ability, the capacity to convey that message effectively. And to that, the Court of Appeal said, well, the effectiveness of messaging is irrelevant to a Section 2B breach. And again, I have to say that that isn't the approach the Supreme Court of Canada has taken in a number of cases, including the election expenditure cases, where both in Harper and in Libman, the court, but especially in Harper, the court talks about, which was limits on third-party election expenses, the Harper case, the court talks about the impact on the effectiveness of the speech being the breach. So from our perspective, the fact that many candidates' electoral to be protected activities were rendered either nugatory or ineffective is the very nature of what is considered to be a 2B breach. And the way that the Court of Appeal deals with this argument in part is to say, and this gets a little bit complicated doctrinally, that really we were advancing a positive claim for positive legislative protection. And we've already heard about the Bayer test and that the conditions weren't met for a positive claim. The difficulty is that the cases that the court relies on, and again, this would be an issue on appeal, Bayer and the DeLille case, which the Supreme Court of Canada has actually overruled in the MPAO case, the mounted police case. Those cases were claims that legislation was under-inclusive by excluding certain speakers from being able to participate. In the Bayer case, it was you couldn't run at all for school board trustee if you were a school board employee. And the Hague case was about who was eligible at all to participate in a referendum, if I remember correctly. So these were exclusion cases, claims that the legislative scheme was under-inclusive in breach 2B. And in that context, the court has said that you have a higher test to meet, and the fact that your speech might be more effective if you were given access to that platform, it's a higher burden to meet. But our case, at least the way we conceived it, isn't a positive, it's not a claim for positive legislative protection. It was actually a claim that the legislation interfered with the freedom of expression in a negative sense, that people were running in the campaign that had been long established, the boundaries were well known, and Bill 5 came and restricted their ability to continue running on the basis of that pre-established campaign. So respectfully, certainly when it gets to the Court of Appeal, one of the issues is going to be what was the view of the three judges hearing the stay application that this was really a positive claim, which the Attorney General argued strenuously. Was that really correct? And just on that point, it's not even clear that the Bayer line of authority applies anymore. There was a case in 2010 where the Criminal Lawyers Association was seeking access to certain records relating to police conduct, if I recall correctly. And what the court said, the Supreme Court of Canada said, and this is their most recent statement on this, but there haven't been really Bayer cases since this case, is that some counsel tried to argue this is really a positive rights case. We don't think we have to resolve that question. We're going to apply the Irwin-Toy analysis and decide whether access to these documents is necessary to permit meaningful discussion on matters of public importance. So two things from that. Number one is the court didn't seem to apply this Bayer analysis. Secondly, again, the court is focused on Section 2B protecting meaningful discussion, and we say that means effective, meaningful expression in the election context. So when the case goes to the Court of Appeal, of course, I don't know that the remedy we were seeking, which was a 47-ward election, is remotely possible at this stage. But it seems to me that someone asked me whether the appeal is going to go ahead. I'm not sure we have instructions from our clients yet, but as to our participation. But as I understand it, the city's been instructed to take any measure possible to continue the matter. And I'm not sure the government can withdraw the appeal because the appeal is, the stay is premised on there being an appeal. So if the government were to withdraw the appeal, the stay would dissolve, and I'm not sure where that would leave all of us. One of the, let me close by talking about how unusual, in a way, Justice Belobaba begins his decision by talking about how unprecedented this intervention in the middle of an election is in Canada. And it's not just in Canada. Like, we've looked around the world to see if governments have intervened in the middle of elections. I think some governments have canceled elections. I'm not sure they're governments, they're more like dictators. But I don't know that any governments that we can see have ever intervened to change the rules in the middle of an election. So although the issues are really interesting and really important in one level, in a way, it's unlikely that this particular constellation of forces will ever occur again. We had the election. We had a newly elected premier, elected while the election took power, while this municipal election was underway. He had happened to sit on Toronto Council when his brother was mayor. It's fair to say that together with his brother, they had strong views about the size of Toronto Council. I think it's true that he didn't run on the issue, but he certainly, they seem to have had strong views. Someone with a particular history and perhaps even character, militating in favor of what some have called vindictive action vis-a-vis the Toronto election. Certainly someone whose election wasn't simply because of 15 years of dissatisfaction with the Liberal government, but there's certainly a populist tinge to his election. And I think that all culminated in Bill 5 and then in the threat to use the override. And just on the override, one can't help but wonder what impact the threat to resort to the override would have on any judges, including the 3 judges of the Court of Appeal. Now, the Court of Appeal is very careful in its reason. It's in paragraph 8 to say that they were not influenced by the undertaking of government counsel, that if the court granted the stay, the government wouldn't take the override bill through the Legislative Assembly. They may not have been influenced by it. I have to say we were, and I think everyone should be offended by it, because it felt, certainly to us, like a threat. And query whether it is appropriate to put a court in that sort of a bind, where if they don't grant a stay, it provokes the override and the potential constitutional crisis that comes with that. But if it is granted, if the stay is granted, the court is at risk of looking like it blinked, given the threat. Now, these are very independent judges of the Court of Appeal. I take them, obviously, they said that they weren't influenced by the undertaking. But I think it just illustrates the risk of a government. I see Sam Hammond here today, and EDFO has a challenge to the proposed change to the sex education curriculum. Like the prospect of a government routinely threatening to resort to the override can't help but have a corrosive effect on judicial legitimacy, and even, I hope this isn't true, but potentially on judicial independence. So whatever the intent of the framers, whatever substantive limits a court might be willing to impose on the override, I think at the end of the day it's sort of up to all of us to make clear that there may be limited exceptional circumstances where the override would be appropriate, but the notion that the override might be used wherever a government doesn't like a charter outcome is really corrosive of our constitutional democracy. Because yes, as the Premier noted, we live in a democracy and he's elected, but we actually have a constitutional democracy. You know, this case will likely continue its journey, although it's, and perhaps I'm sure we will come up with creative remedies should we be successful in the Court of Appeal as to what to do about the fact that the election, if we're successful, was unconstitutionally altered. But I think it's fair to say that for the moment, the drama of whether there's going to be a 25-ward election or a 47-ward election, that part of the case is over, and we were unsuccessful.
So we have some time now for questions. We just ask that there are some handheld mics. So if you have a question, please ask the question into a mic so that anybody who's watching online can hear and that it gets recorded. So we have a question up here at the back. Sarah, over there.
Hello, thank you. On the subject of factors that the Ontario Court of Appeal didn't explicitly reference as being behind their decision, I'm curious about where you would draw the line on to-be expression. Where does the effective speech of candidates end? Because it seems that some kind of speech right to a campaigning activity should obviously continue during the election, but does that mean the provincial government could, you know, abolish the City of Toronto the day after the election? That would seem to have rendered the campaign speech ineffective also. Or could they abolish it before the end of a 4-year term? That would also make all that campaigning no longer in line with the expression that the candidates were doing, and maybe even the powers of the candidates if those severely changed. You know, if City of Toronto no longer dealt with transit and all their campaigning was about transit. So where do you draw that line? And I mean, I kind of feel that the difficulty of drawing that line is probably part of why the Court of Appeal didn't want this argument.
Yasmin, do you want
It appears to be falling to me to answer that question. Well, I think it's, you know, the charter cases always depend on context. And so I think your first example, which is abolishing the City of Toronto, that's one of your examples, I think that would be a harder freedom of expression case than this case. I'm not sure that would be a freedom of expression case, but in the context of a decision that there is going to be a City of Toronto and there is going to be an election and these are going to be the boundaries and rules that apply to that election, you know, the specter of hypothetical horribles would leave us with no constitutional rights protection. So in the context of this case, one doesn't have to draw that line because this is on the side, on the breach side in our submission of whatever line there is. But I don't disagree that line drawing and how to draw the lines is something that worries judges all the time. I just think it depends on the case and the context. But good question.
I have a question down here.
Now, my son is in first year law and he's arrived here, so someone should get him to ask a question. He's right at the back hiding.
He doesn't want to ask.
No, I don't think so.
Okay, Professor Reinrod, I'd want you to tell us the facts, the actual facts of the Ford case in which they used the retrospective principle in the Supreme Court. What are the facts? I have no idea.
What were the facts? Oh,
yeah.
of course,
Oh, yeah,
yes.
yeah. So
okay.
you could, what was passed and what did they say about it when it was challenged and why was it challenged? And secondly, to Professor Barrett, I think you agree here, if the province were to pass a law saying the Toronto City Council would be appointed by the Premier, that would be perfectly constitutional. If we were to pass a law saying there should be only one member of the Toronto City Council, elected and nobody else, they would also be constitutional. Do you agree?
I'll let Professor Weinrib lead.
Okay, so the Ford case. So I set it up a little bit. Yeah, I didn't go into the details of it. So the charter was, the charter came into force in April of 1982. Quebec was enraged. And as I say, not so much, I think, the population, because they like rights and they have very strong rights protection, but this had become a political football in the separatist movement. So what the Quebec government did, as I said, is they decided to use the override in the maximal mode possible. So into every statute that existed, into every new statute, into every amendment. First thing. The suspension instrument mentioned all the rights that could be overridden, the fundamental freedoms, legal rights, and equality. So as the Court of Appeal in Quebec said, the Sugar Refinery Act has this omnibus override over all of these rights. This is incoherent. Okay, so that's the second thing. And law school can't afford chalk. Okay, so you should be paying more tuition so we can have chalk.
She doesn't really mean that.
Okay. The charter comes in. Quebec has to cook up this idea of this incredibly extensive use of the override, because we barely knew the override was there at that point, right? The Globe and Mail was still saying, look, there's a section 1 in the charter. What's this? They snuck this in and no one told us about it. Okay, so and also they had to draw up the legislation, which is very complicated, all the past, all the amendments. So it wasn't until June of 1982 that they actually put the override in place. So they used it for every new statute and for every new amendment to every old statute, but that's prospective. They also expressly made it retroactive from June, when they enacted the override legislation, to April, because they wanted the population of Quebec never to have had a moment of charter rights. But meanwhile, of course, you live in real time. The override comes in and changes it, takes the rug out from under you, so to speak, after the fact. So there were lots of court cases. A whole group of the court cases were commercial speech cases, so not core, and the court hadn't yet decided that there was commercial speech in Section 2B. So most of the people who know about the case know it because all these people brought their commercial sign litigation. It was a nightmare for the separatist government because the commercial rights claim they were making is they had choice of language in commercial signs. They could use English and or languages other than French. And they made those claims. So if the override was retroactive, those claims couldn't have been heard. If it was effective to take away the claims in the period between April and June, took that away, it would be retroactive, and all those language rights claims in the commercial context couldn't have been raised. Okay, so we got to the Supreme Court of Canada. I was the only one who realized that they had used it retroactively. And I thought, this can't be right. You can't have a right. You can't have a right, exercise the right, and then have the right taken away later. It's just incomprehensible. There were no charter principles. There was nothing. It took me a full month to write the factum because I challenged that. I challenged this blanket override and the routine use of it. But anyway, I was successful in this. So on the facts, all of these, the override was declared to be ineffective retroactively, and all these cases went up to the Supreme Court, and the court said yes, there is commercial speech. The use of language in your choice of language in commercial signs is protected. And so in this period that Quebec had hoped to insulate from charter protection, after the fact, those cases went forward. Okay, now, one of the very interesting things about retroactive application is, why wouldn't a government use the override forward for 5 years and backwards for 5 years at the same time? Then it's got 10 years. That's inconsistent with the text. So, and so you've got rule of law arguments, and you've also got, ironically, in a case that's all about temporal stuff, like that the election was in midstream and what's to be right retroactively, that the question of the retroactivity also raises this temporal question of it. You know, it says the override is that it shall suspend the rights in the future for 5 years. So how do you count if you can use it retroactively? So those are the facts.
But it does illustrate the difference between this. Let's assume that Justice Belobaba is upheld in the Supreme Court of Canada or something like that. And then there's an override. This case is somewhat different than that case in that these were discrete acts pre-enactment of the legislation that the override couldn't apply to. In our case, the government will argue, no, it's just looking forward to the acts that happen after we pass the override, if they would have passed Bill 31. And our answer to that, and I think this is an open question, but I think our answer is better, is that you have to look at what we've been talking about, an election as a continuum. It's impossible. Sure, strictly speaking, technically, one might only be looking forward, but given the nature of an election, one can't help but also catch prior activity prior to the override in the sweep of your override, and therefore it can't be effective. So I think that's both the distinction with Ford, but also a reason that the override here would have been problematic. On your second question, could the Premier appoint the mayor or appoint a single representative for Toronto? Or now, this is actually what the Premier did here. There were elections for certain regional councillors, and he's now made them appointments instead of elections. It would be a different case, for sure. I think it is true that the status of municipalities and municipal government in Canada is frail when it comes to constitutional protection, and so people have begun to talk. There's some question about whether the federal government and a willing province could make an amendment only for that province to protect municipal government or give municipal government some constitutional status. It's unlikely that agreement will be reached in Ontario for at least 4 years.
Now, I know we
There's
have
an
one.
interesting, if I could just interrupt, there's an interesting structure of the federalism of the modern German constitution, in which the major cities are themselves provinces. So you wouldn't have to
That would be
create
another
a new
way to-
structure.
I don't know if you can create a new province on your own without the other provinces agreeing, though.
Yeah,
Hamburg and Braden,
that's right, yeah.
not the others, just within Hamburg and Braden.
But it would, like, making a construct for municipalities would be a challenge, so.
So we have one more question, I think, up at the back, and sorry, and because we're coming close to our time, so if we can have just one more question, or maybe we can have both, and then we'll close on the two questions. So go ahead.
You know, it's okay. I'll hold back because.
I
So
bet it was a great question.
I think Louis, whose name I invoked earlier when he wasn't even here, so now he's looking a little puzzled. Why was she mentioning me? But Louis has a question down here.
Yeah. Actually, both Louis and Gita are here.
Yeah.
I was going to ask the bilateral question, actually, and just as a tag onto that, whether you think that could be a campaign issue. And I've noticed just in the last week or so, I don't know if you can recall a more vibrant period of civic education about constitutional law. I've never had taxi drivers give me their theories of cases I'm involved in. Their, views on the Notwithstanding Clause volunteered to me as they overhear discussions. So it seems to me like there's something, in, like we could keep this going, and maybe whatever government wants to pick up the issue for the next election, actually make this a real issue. And maybe you could just give me your thoughts on that. But the other question I was going to ask maybe Lorraine is, do you think the risks of your proposal of a reference question, are the risks of disappointing judgment worth it, in the sense that if you put it to the court and they find that there are absolutely no substantive limits at all, and then we're stuck with that, or are we maybe better off just continuing to fight our more kind of fluid battle that we've been fighting in the realm of norms? I guess I'm just kind of interested in that.
Yeah, well, of course, you never know till after the fact. The court has done such amazing things with constitutional principles, and then it's done it all in these situations where, because of our clunky, outdated, colonial, fragmented constitution, that they've done it in situations where, as they say, they have to fill gaps, or they have to build the structure, and that the constitutional, and they've said, but I don't think they've actually actualized the idea that these constitutional principles could be directly applicable. I mean, and and I think that, I don't know, I've been trying to count up the members of the court that I think would be receptive. I think that any judge on the Supreme Court of Canada would be receptive if they actually saw the jeopardy of ending up in a situation like Trump has created, and this, what's threatened here, which is where the whole charter project is turned inside out, upside down, and so I think that that's I think that there could be a good result, but of course you never know. But it's not. It would be much easier to argue those points now than it was for me to argue them last time, because the judges were levitating. They were so angry at me. It was just. I mean, I've seen them very angry in very serious constitutional cases, because I was in the government. I was on all those major cases, but they were really just stricken with the idea that the override might be another subject of judicial review, and they would have cases. They just, but of course, they couldn't have expected that this great sort of constitutional convention against using it and calling it the nuclear option, which is sort of a proportionality analysis of it. They couldn't have predicted that that would happen. But what you describe is really good, because I'm so busy thinking about this and trying to figure out sort of how an election fits into freedom of expression. I haven't been taking any taxis, and so if people are talking about this that way, that's why I think, in a sense, we need the override, because we have to fight for our rights. We have to really believe these are our rights, and they're really important, and they have to be part of the supreme law, and they have to be the norm and not the exception. And so the times when we actually, have to forget about everything else and actually say, well, are we going to have a constitutional democracy that protects our fundamental rights, or aren't we? And so we have to stand up and show the Ford government that this can't be part of his toolkit, as he says. This is not a norm. And I would just disagree with Steve. People always think I'm making an original intent argument. I'm making a design argument of the design of the Constitution. And so and I think the understanding of people who actually saw what the bargain is a very, very valuable insight.
That's sort of an original intent argument, and I'm not saying actually there is a design argument for sure. The problem with the design argument is the language of Section 33. I would put more faith in the taxi drivers than in a reference to the Supreme Court of Canada, and I think a reference would be the absolute wrong way to have this issue resolved. I would be really leery.
Well, I prefer a real case.
Because a real case, and there will be one at the rate we're going, a real case, I think, gives it's just a better context in which the court can determine. I think it's very hard. It will be I think there's lots of good arguments that we will make if we ever get a case in front of the courts around the override, but I think the courts are going to be balancing the considerations that Lorraine's been talking about against judicial legitimacy, and I think they'll be concerned about placing real substantive limits beyond retrospectivity on the override. I think there are good reasons to argue there should be, but I think it's going to be it's a difficult challenge, and doing it in the abstract, I think, is the wrong way to do it. So let's keep those taxi drivers fighting against the override, and maybe we'll be in better shape.
I'm going to give Professor Dawood the last word.
Okay, thank you. So, I mean, to pick up on this issue of the unwritten principles of democracy, I was actually really hoping to see something on that, just because I think that, for example, one way to deal with this entire problem is to say that one of the unwritten principles of democracy is that the election period is you can't change the rules midstream, for example. Right? So if you had that kind of unwritten rule, that just basic assumption of procedural fairness, basic assumption of electoral fairness, that there is something like an election period, the rules have to stay the same right through the election period. If you had a court, let's say the Supreme Court, recognize that one of the unwritten principles, that the unwritten principle of democracy actually does mean that you cannot interfere with the rules midstream, I think that would be a very important way to protect elections from this kind of interference, like municipal elections or even other elections, from that kind of legislative intervention or that kind of gaming or pressing, trying to come up with a certain outcome. And it just also just seems that it coheres with our general ideas of fairness, that you can't change the rules midstream. So in terms of candidates for using the unwritten principles of democracy, it seems to me like that would be one that would work, in addition to some of the things on the Notwithstanding Clause, to sort of put some limits on it. And so in the event, for example, that, let's say, Premier Ford does abolish the City of Toronto or just abolishes all elections, I mean, what would happen in that situation? My hope is that, in fact, at that point, the Supreme Court would have something to say and would, in fact, invoke the unwritten principles of democracy and the rule of law to come up with some sort of response to that kind of eventuality, if it did come to pass.
So that argument was made in this case by Don Eadie for some of the interveners, and I think it's fair to say that Justice Belobaba gave it short shrift, and it really wasn't pressed in the Court of Appeal on the stay application. But I suspect on the appeal, it will be, assuming it's not found to be moot somehow, it will be argued. And of course, the advantage of the unwritten principles, if one could ever get a court to say that they apply to strike down legislation, which, to be fair, hasn't happened yet, is that they can't be overridden by Section 33. So all kinds of interesting possibilities.
And actually, the interesting thing about using constitutional principles in this context is every single one that the court has used in the whole range of cases is engaged here, and the court has talked about their symbiotic relationship. So it would be the biggest constitutional principle case imaginable if this got up there.
So I think we're going to have to continue the conversation in our taxi rides home because we've gone over time. I want to thank all of our panelists for their analysis. Thank you very much.